Hello, everybody. So I'm here to talk to you about the cognition of contract interpretation. And by that, I mean what it is we are doing, what it is judges and lawyers are doing when construing a contract. I've already plugged the book a few times, Unified Approach to Contract Interpretation. And that's what I'm speaking to here. And I appreciate that some of the people watching this seminar are not necessarily contract lawyers or private lawyers. So for that reason, I want to set the scene. So I want you to imagine that you're at a cafe. There's two people chatting at a cafe, and they seem to reach an agreement, and you're watching them. In fact, you've been asked to determine what it is that they've agreed on a particular point. The problem is that they haven't quite reached a clear agreement on that point. They've sort of reached a vague agreement on it, or they've said one thing and then they've said another thing. They've sort of been inconsistent, or they seem to have meant something else from what they said. They seem to have made a mistake. So that process of you sitting there trying to figure out what these two people have agreed on a particular point, that's quite similar to what the judge or lawyer does when construing a contract. These are the parties, their little exchange is the contract, and maybe you're this person here looking at them, trying to figure out what they agreed. Now, the purpose of this talk is to discuss the approach to the interpretation of wholly written contracts. And what is on this slide here is a typical statement of principle, one of the more recent statements of principle from the UK Supreme Court. And you'll see in the first part, it states the aim. The aim is to ascertain the reasonable person's understanding of what the parties intended. And then the rest of the statement of principle lists all these things that you need to consider to arrive at the reasonable person's understanding. The natural and ordinary meaning, the apparent meaning of the words, the whole contract, the purpose of the clause or the contract, the background, and commercial common sense or results, the consequences of the competing interpretations. But you're not allowed to look at evidence of what the parties actually intended. So if we go back to your cafe situation, if you're sitting there trying to figure out what these two punters agreed and the meaning of the words doesn't quite get you there, then you're looking at, okay, well, what was the background to the meeting? What was the purpose of the meeting? If I reach one conclusion, does it give rise to an absurd outcome such that that can't be what they agreed? That's just a little bit of an introduction to the uninitiated. So my interest in contract interpretation grew from the fact that, well, I wondered, how do we look at all these things to reach this conclusion? And then to make it a bit more complicated, how do we look at all these things to reach this conclusion and thereby fulfill the functions of what interpretation does? Namely, it's a process through which we resolve ambiguity in a contract, inconsistency in a contract, or we correct obvious error. So how does this all work? How does it fit together? And to attempt to summarize the book in quite a long sentence, this is where I reached as a matter of theory. So contract interpretation is a process through which we establish the objective intention of the parties. What was objectively intended by the choice of words in the contract in answer to a particular question of interpretation. So we're trying to figure out what the parties objectively intended by the choice of words in the contract. But we're not simply doing that. We're trying to figure out what they intended by the choice of words in relation to a particular question of interpretation. And that's where you get the ambiguity or inconsistency or apparent error. For example, inconsistency. You're trying to resolve a particular question. You're trying to figure out what the parties agreed on a particular point, but they agreed one thing in one place and one thing in another place, and they conflict. So that's where I reached as a matter of theory in my research. And then I dug deep into those parts of the judgments, not the parts of the judgments where the judges make the statements of principle, but those parts of the judgments where the judges apply the approach, where they actually engage in the process of interpretation. And what I found looking at the cases is you have this very short paragraph that is then followed by 8 to 10 pages applying that approach. A little bit more is going on than simply what is revealed by this paragraph. And the position I reached after looking at all these cases is that the interpretive process can be conceptualized in 4 steps. And the first step is defining the question of interpretation. What is it that you need to figure out about the parties' agreement? And that question of interpretation is inevitably defined by the dispute. So the parties have a dispute. The court has to figure out, okay, well, what did you agree on this particular point? And they try to figure out, okay, well, what did you agree on this particular point by choosing the words in the contract? So you need to define the question of interpretation first. Then, usually, each party puts forward potential answers, potential interpretations, potential answers to the question of interpretation. And then the most intensive part is formulating arguments. So once you've figured out what the question is, once you've figured out the potential answers, usually one party puts one forward, the other party puts one forward. Then you need to search all of the admissible materials to identify arguments in favor of one construction or another. And those arguments are built from the meaning of the words, the whole contract, the purpose of the clause or the contract as a whole, the background or commercial common sense, in particular the consequences of the competing interpretations. Right, that's the structure of it. And then once you ventilate all of those arguments, you look at them all and you figure out what did the parties probably intend in answer to the question of interpretation in light of all of these arguments, in light of all these interpretive factors. Now that might be a bit hard to digest on its own. So I'm going to run through a few hypotheticals and I may go a bit over time, but then I'll look at a couple of real cases. So imagine this fairly simple contract. Party A agrees to sell 50 kilograms of apples to Party B for $100. Now imagine Party A delivers red delicious apples. Party B says, no, this was a sale of pink lady apples. What are you talking about? This is a sale of pink lady apples, not red delicious apples. Now, the question of interpretation is, what type of apples did these parties objectively intend they were selling? Which type of apples were meant to be the apples sold pursuant to this contract? Now, Party A says, well, you know, any kind of apple was meant to be sold pursuant to this contract. Party B says, no, this was for a sale of pink lady apples. Now so they're the competing interpretations. Party A, any kind of apple. Party B, pink lady apples. Now Party A can rely on a pretty solid argument here. Apples means any kind of apple. Party B can also say, well, apples means pink lady apples, but that's a bit of a stretch. I think on these facts, Party A probably wins. But as Lord Wilberforce pointed out in the Diana Prosperity, no contract is made in a vacuum. So we need to extrapolate these circumstances to make it a bit more realistic. So same contracts, but I want you to assume that the market price of pink lady apples is $2 per kilo. And all other apples are much cheaper. Again, Party A rolls in with his red delicious apples, and Party B says, no, this is a sale of pink lady apples. Party A says, no, well, apples means any kind of apples. Party B says, no, apples can mean pink lady apples, and more to the point, I can rely on a contextual argument in favor of the conclusion that we intended a sale of pink lady apples, because the contract price coincides with the market price of pink lady apples at the time of contract formation. Now who wins? Now what did the parties objectively intend? Does B win now? Let's change it up a little bit more. Same contractual formulation, except to A's knowledge, B is widely renowned and marketed as a vendor of only the finest fruits. Now you have to assume that red delicious are a rubbish fruit and that pink lady are a fine fruit, which I think most people would agree. On these facts, assuming that to be the case, when A rocks up with his red delicious apples, Party B can say no, apples can mean pink lady apples, and there's also a purposive argument that Party B can draw on. we objectively intended a sale of pink lady apples because pink lady apples are fine fruit and you knew that I was a vendor of only the finest fruit. That's not a great purposive argument. It's a little bit flimsy. So let's change it again. So what if we've got a little preamble in our hypothetical contract? Party A and B are committed to local fruit production. Pink lady apples are locally sourced and all other apples are imported. Party A rocks up with the red delicious. Party B says, no, this is a sale of pink lady apples. Your argument that apples can mean any type of apple, that's not strong enough to overcome my argument that apples can mean pink lady apples. And more to the point, the purpose of this contract is evidence from the text. And in light of background, the only locally sourced apples are pink lady apples. This must have been a sale of pink lady apples. The objective intention of the parties by these words, the objective intention was to effect the sale of pink lady apples. I think Party B's in a better position here. I think Party B probably wins this now. Probable intention of the parties looking at the contract as a whole was for a sale of pink lady apples. Now you see the difference there between these two examples. In the previous one, the purposive argument's a little bit flimsy and it's founded outside the text. Whereas with this example, the purposive argument that a sale of pink lady apples was objectively intended is founded in the preamble in light of background. So far we've really been looking at examples of an interpretive dispute involving ambiguity, semantic ambiguity, different meanings for the word apples. But as I pointed out at the start of this talk, through interpretation, the court not only resolves ambiguity, but it also deals with inconsistency and it can correct obvious error. What about if we change the contractual formulation? Party A agrees to sell 50 kilograms of red delicious apples to Party B for $100. The market price of pink lady apples is $2 per kilo, and the market price of red delicious apples is 20 cents a kilo. Party A rocks up with the red delicious apples. Party B turns around and says, no, this was a sale of pink lady apples. Now, Party A would say, what are you talking about? What are you talking about, Party B? Red delicious apples must mean red delicious apples, and that's the end of it. Well, can Party B establish an obvious error here? Party B can point to two arguments that by using the term red delicious apples, the parties actually intended a sale of pink lady apples. Those two arguments are the contextual argument that the contract price matches the market price for pink lady apples at the time of formation. That's probably not enough. And there is also a consequentialist argument, an argument based on results. A sale of red delicious apples would be a sale at 10 times the market price. Is that enough to establish that despite using the words red delicious apples, and the words red delicious apples can only really mean red delicious apples, can Party B, by reason of these factors, establish that by using these words, these parties objectively intended a sale of pink lady apples? And I don't think Party B can. That would allow Party B to escape from a bad bargain. But what if we change it one more time? What if we change it one more time? What if we have the preamble? Party A and B are committed to local fruit production. Pink lady apples are the only locally sourced apples. Red delicious apples are imported. Here, Party A would be relying solely on the argument that red delicious apples means red delicious apples. Party B's got the contextual argument arising from the coincidence between the contract price and the market price, can rely on a consequentialist argument that it would be absurd for a sale to be at 10 times the market price, and probably most significantly, can rely on a purposive argument grounded in the text, suggesting that this was a mistake and that the parties had intended, objectively intended, the sale of pink lady apples by using the term red delicious apples. Okay, so I accept that's pretty complicated. And you might think, Ryan, this is crazy, what are you talking about? But there are cases, for example, the ICS case, where the court does stray quite far from what would be the apparent meaning of the words in arriving at the reasonable person's understanding of what the parties objectively intended. So with that little run through a few hypotheticals, I'm just going to run through two cases to show you how the interpretive process works in action, and it builds on those hypotheticals. The first case is Pren and Simmons, which involved a share sale agreement. And here is the share sale agreement. So what happened in this case is Pren had acquired this company, Radio and Television Trust, to secure the services of Dr. Simmons, who worked for a subsidiary of Radio and Television Trust. Now, Mr. Pren had paid £160,000 in cash to acquire this company, and there was outstanding £294,716 that Mr. Pren had to pay for this company, and he had to pay that over 4 years. So that's the background. So at the same time as Mr. Pren acquires this company, Mr. Pren enters into the share sale agreement with Dr. Simmons, who works for a subsidiary of this company. And this is the share sale agreement here. These are the words of the share sale agreement. So Pren agrees to sell the shares in Radio and Television Trust Limited to Simmons for £6,600. But the share sale is subject to two conditions. Well, the share sale will only go ahead if one of two conditions are satisfied, A or B. A is satisfied if £294,716 are paid to the vendor from whom Pren bought Radio and Television Trust through the redemption of preference stock. That didn't happen. The contest was whether the share sale was triggered because Clause 2B was satisfied. Clause 2B provided that the share sale would go ahead if the aggregate profits of RTT earned during the 4 years, blah, 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 whether declared or not, shall have amounted to £300,000. Now, what happened? What happened that led to the interpretive dispute was that RTT Limited, over this 4-year period, did not earn £300,000. The RTT Group, including its subsidiaries, did earn over £300,000. So the interpretive question was, which profits were to be counted under this clause in determining whether Clause 2 was satisfied and the share sale would go ahead? Pren argued that you only count profits of the holding company, RTT Limited. Simmons argued that you count the profits of the RTT Group. So that's, you got the question, which profits do you count? You've got the two interpretations. You either count the profits of the holding company or the profits of the group. Mr. Pren argued that you only count the holding company profits, RTT Limited's profits, and he had a pretty good linguistic argument, an argument about what RTT meant. It was defined to mean RTT Limited. There was also an argument that aggregate profits was defined in the company's legislation to mean profits of a holding company, but that you don't necessarily just apply a definition for legislation in construing a contract. So the main argument that Pren relied on was that RTT was defined to mean Radio and Television Trust Limited. That would ordinarily be a very good argument. However, Clause 3 seemed to use the term RTT as referring to the RTT Group because it referred to Dr. Simmons being employed by RTT either directly or through any of its subsidiaries. So that weakened Mr. Pren's linguistic argument. In opposition, Dr. Simmons said, well, look, RTT can refer to the RTT Group. It can mean RTT Group. The fact that Clause 2B referred to profits earned when RTT Limited didn't trade must mean that it's referring to the RTT Group. The fact that the RTT Group prepared consolidated accounts that treated holding company and subsidiary profits as one and the same, again suggested that the RTT Group profits were to be counted. And perhaps most significantly, Mr. Pren, Dr. Simmons rather, could point to a purposive argument that the whole idea of this condition triggering the sale was to incentivize Dr. Simmons to generate profits for the RTT Group so that Mr. Pren could pay off what he owed on the acquisition. And if you didn't count group profits, that would defeat the whole purpose. So in the end, Dr. Simmons prevails. The House of Lords concludes that RTT here is referring to RTT group profits. As a matter of probability, the objective intention of the parties was that if the RTT group earned over £300,000, then the sale would go ahead. And that made sense because the whole point of this regime was to incentivize Dr. Simmons to make enough money so that Mr. Pren could pay off what he owed on the acquisition. So that's Pren and Simmons. And when you look at the argument composition, it's really quite one-sided. Mr. Pren was simply relying on the argument that RTT meant RTT Limited, but Clause 3 suggested that that term could be used in two ways. And then the purposive and contextual arguments were really in favor of Dr. Simmons. So hang with me. I know we're nearly there. I know it's tough, but you've got to get down and dirty with these cases to truly understand them. Now, Arnold and Britton, moving forward in time. This involved a lease of holiday homes. Lease of holiday homes described 99-year leases of holiday homes in South Wales at the Oxwich Leisure Park, described by Lord Carnwath as an attractive holiday location. I will let you decide what you think about that. I think when I did part of this talk in the UK, I suggested that we had a different idea of a holiday location in Australia. Looks lovely, nice green lawn there. You can see Professor Bigwood sitting on that chair, bit of sun, really enjoying himself. So anyway, the dispute here related to, so there were quite a number of these leases, and they were executed sort of 1980, 1985, 1990. And pursuant to the lease, the rent was £10 per annum, increasing by £5 per annum. The dispute arose about this clause, because under this clause, the lessee was obliged to pay as a proportionate part of the expenses and outgoings the yearly sum of £9 for the first year, increasing thereafter by 10% per annum. So these leases are agreed 1980s thereabouts. This one in particular, they're slightly different in form, but this one represents the 14 that were executed in 1980. Now, what happens is fast forward to 2015, and the rent, the amount, the quantification of this sum it's getting quite large. So in 2015, the amount of this charge was £2,500, and by 2072, it would be £550,000 per year in terms of expenses and outgoings for this holiday home. So the interpretive question was whether this Covenant 3.2 obliged the lessee to pay a proportionate part of expenses and outgoings or the sum of £90 increasing by 10% per annum. Now, what the tenants argued, they said, look, they mainly relied on a consequentialist argument. They said it can't be this £90 per annum increasing by 10%, because it would lead to these ridiculous sums of £550,000 per annum. It cannot possibly have been intended. The tenants also relied on this part of the clause. They said the idea of this provision is that we pay a proportionate part, not this index sum. What they said, they tried to explain the blue part by saying, look, it's a cap. We pay the proportionate part up to this cap. In opposition, the landlord said, no, the words are clear. You agree to pay the yearly sum of £90 increasing by 10% per annum. As a matter of purpose, this achieves certainty. This stops the disputes that often are up between lessors and tenants in these sorts of circumstances about figuring out what a proportionate part is. The lessors ultimately succeeded 4-1, and I think in large part because they could explain the agreement to pay £90 per annum increasing by 10% each year on the basis that inflation was quite high when these leases were agreed. This agreement to pay £90 per annum increasing by 10% was a bilateral gamble on inflation. The tenants lost, the landlords won. We're not going to let you out of your bargain, although I think there's some discussion about whether they get out of it through legislation. I don't think they could. But the conclusion of the UK Supreme Court was that the clause is quite clear. You agreed to pay a yearly sum of £90 increasing by 10% per annum. and that agreement can be explained as a matter of commercial purpose. You agreed it as a bilateral gamble on inflation. And that's all I have to say. Thank you for sitting through that.